Private companies that encounter fraud by senior management of company resources have limited recourse. Practically speaking, directors are ultimately held responsible for liabilities under company law, tax law, and various other statutes. But as a foreign investor, becoming a director exposes you to significant liability risks. Governing Indian operations requires a balance. Best approach is to put in place multiple layers of safeguards. Hello and welcome back to the Veyrah Law series. In the last episode, we discussed ways to mitigate director liability. Today, we tackle a related issue that comes up when adopting a de-risking method for director liability. If you do not appoint directors on the board, how do you actually oversee your Indian operations? My name is Ajay Joseph. I'm a partner at Veyrah Law. You can find more information about me and Veyrah Law on our website. The link is in the description below. Before we get started, a quick reminder. Please read the disclaimers carefully. With that done, let's start with today's topic by understanding the issue. Directorship in India comes with many risks. In a joint venture company, keeping reporting lines with shareholders is a good way to mitigate risk. The Indian partner manages day-to-day operations, and the reporting lines keep a visibility for the foreign partner. But this becomes a bit of a challenge when the Indian operations are completely owned by the foreign parent. While the law regarding corporate governance standards is at par with most developed countries, enforcement delays and practical realities on the ground create gaps. As we have discussed in earlier episodes, litigation in India can take years. This means that the law, while well-drafted, is not always an effective protection in practice. Neither are contracts, if enforcement takes years. This creates the issue of corporate fraud by professional management teams. In recent years, India has seen multiple high-profile cases of corporate fraud. The PNB fraud, where allegedly fraudulent letters of credit were issued, leading to losses of nearly $2 billion. The Yes Bank case, where the CEO was accused of receiving kickbacks for sanctioning loans to companies who had little ability to repay. The bank concealed bad loans worth billions of rupees through evergreening and dressing of accounts. These are not small-scale frauds. These are systemic failures involving sophisticated accounting manipulation, collusion, and failure of oversight. While these are frauds of large value, we're also seeing an increase in client matters of foreign companies with wholly owned operations in India, where the senior Indian management has been found involved in potential mismanagement and misappropriation of company funds and resources. What makes the situation worse is that unless it is a fraud that involves public money, government investigation agencies do not get involved. Private companies that encounter fraud by senior management of company resources have limited recourse. Practically speaking, it is a challenge to work with local police stations to file cases for corporate fraud involving private businesses. In our experience, in Mumbai at least, the Economic Offences Wing, which is the specialized division of Mumbai Police for financial crimes, is swamped with high-value cases involving public funds and will rarely be convinced to take on a private complaint. You have other options: pursuing wrongdoers by approaching a magistrate directly under criminal laws, or pursuing court remedies against the individuals in question. But the practical challenges, time delays, legal expenses, procedural hurdles make these options unattractive. Usually, the best solution as a post-incident action is to negotiate a settlement and remove the tainted management. But by then, the damage is done. So here is the dilemma. As a business operating in India, the surest way to manage governance will be to control operations directly and have trusted directors on the board. For most private companies, the CEO or managing director operates the business with first-level executives. Directors are ultimately held responsible for liabilities under company law, tax law, and various other statutes, as we discussed in our previous episode. But as a foreign investor, becoming a director exposes you to significant liability risks. On the other hand, relying solely on professional management in India without proper oversight mechanisms is also fraught with danger. So, what can foreign businesses do? Let's start with strategies that apply to joint ventures or for mitigating director liability risk. These are measures we have discussed in earlier episodes but are worth repeating. First off, observer status on the board. Instead of taking a director position, opt for observer status. Board observers can attend meetings, receive all information, and participate in discussions, but they are not directors. This protects you from director liability while maintaining visibility. Keep professional executive management as directors on the board of the Indian company. Second, visibility in banking operations. Ensure you have access to bank statements and visibility into financial transactions. This is one of the most effective early warning systems for financial irregularities. If cash is being siphoned off or transactions are being hidden, you will see it in the banking records. Next, material operational decisions should require shareholder approval. Embed decision-making rights at the shareholder level and include these rights in charter documents, so third parties become publicly aware of approval requirements. Major expenditures, borrowing, key contracts, related party transactions, all these should require shareholder consent. This gives you control without the liability that comes with being a director. Next, ensure detailed financial and MIS reporting. Ensure comprehensive reporting requirements, monthly management accounts, quarterly financial statements, operational reports. The more visibility you have, the harder it is for financial mismanagement to occur undetected. Another measure is to ensure direct CFO reporting to the board and shareholders. Agree to have a CFO or senior finance person who reports directly to the board and the shareholder body. This person provides regular reports to shareholders, ensuring transparency. The CFO and CEO should have direct reporting lines to the board and the parent company. Also arrange regular informal visits. Don't just rely on formal board meetings and reports. Make regular informal visits to the Indian operation. Walk the floors. Talk to employees at different levels. Meet customers and suppliers. These informal interactions can reveal things that never make it into official reports. A culture of fear, corner cutting, or management high-handedness often shows up in casual conversations. Another important step is third-party statutory auditors. Ensure that your statutory auditors are reputable, independent firms with no conflicts of interest. In India, auditors are mandatory for companies, but the quality of audit matters. A rigorous auditor can catch irregularities early. Make sure that the auditor reports to the board and has direct access to the foreign company. An additional protection that could be considered are forensic audits every 3 years. But this is not something we see usually. Beyond the regular statutory audit, consider conducting a forensic audit every 3 years. Forensic audits are designed to detect fraud and financial manipulation. They go deeper than a regular audit, examining transactions, tracing cash flows, analyzing patterns. This may seem expensive, but it's a fraction of the cost of dealing with financial fraud after it happens. Think of it as preventive medicine. Another measure that we have seen which could be useful is whistleblower policy with incentives. Implement a robust whistleblower policy that protects employees who report irregularities. But go a step further. Provide incentives for whistleblowing. This could be financial rewards for credible reports that lead to corrective action. The goal is to create a culture where employees feel safe and motivated to speak when they see something wrong. Many frauds and wrongdoings are known to junior employees long before they are detected by the management or auditors. Lastly, use court or criminal proceedings to make an example. If you do detect fraud or misconduct, don't just settle quietly. While we always recommend settling in a commercial disagreement, in matters of serious financial wrongdoing by individuals entrusted to run operations, we have a different approach. If the financial wrongdoing becomes public, it is important to set an example publicly. Consider pursuing legal action, even if it takes time. Why? Because it sends a message. It shows your employees, your vendors, your customers and other potential wrongdoers that your organization takes fraud seriously and will pursue consequences. Yes, litigation in India takes time, but sometimes the deterrent value of a public prosecution is worth its effort in gold. To sum up, governing Indian operations requires a balance. You need trusted hands to run the show in India, but relying solely on trust is risky. Directorship from the parent company could provide control, but it exposes you to significant liability. The best approach is to put in place multiple layers of safeguards: third-party statutory and forensic audits, banking account visibility, whistleblower policies, and such other measures. No system is foolproof, but by implementing these practical measures, you've significantly reduced the risk of fraud and mismanagement in your Indian operations. As someone rightly said, the cost of prevention is always lower than the cost of cure. On that note, we hope you found this video useful. If you did, please do share it with others who may benefit from it. And as always, if you have questions or topics you would like us to cover in future videos, drop them in the comments below or send us an email. Someone from the team will surely get back. Thank you for watching and see you in the next video.